thought we would do today as a follow-up in part to Michael Kelly's summary of the CRA law to you guys is maybe do, you know, a little bit of review in a sense in terms of sort of comparing the old Chin's now CRA law to the care and protection laws, and then also looking ahead to the delinquency cases which are going to start next week. So just in terms of review, so a care and protection case, so just for example, you guys just did the, you know, the Sissy Harrison care and protection / termination case. And remember when, you know, the clerk was going to call the case, oh, what's the name of the case? Is it, you know, is it DCF versus, no, it's care and protection of, because it's a case about children, right? So a C&P case would be care and protection of, you know, say the Harrison children. The CRA case is similar as well. It's not, you know, Commonwealth versus Sissy Harrison. It's not the department versus Sissy Harrison. It's also an in-re type case. CRA, say, of Sissy Harrison. And we'll talk about, I want to review the subject matter jurisdiction for the CRA. I know Michael went through it, and he gave you guys so much information, and I saw you taking notes. And I'm thinking that people are still a little bit confused, so I'll come back to that. Looking ahead to the delinquency cases, now is when you have the state versus your child client. So the delinquency cases, the YO cases, it's always going to be Commonwealth versus whoever the child is, Sissy Harrison, the defendant, or the juvenile.
Is that where you're going to see criminal charges?
Yes, yeah, and those are the cases we'll start next week. Although if I want to get to today, you know, the cases that are sort of tie over incidents that sometimes happen at school that could be the basis for not only a CRA petition, but also the basis for, you know, the police arresting and subsequently prosecuting the child. So in the care and protection cases, what's the burden of proof? In the care and protection cases, what's the burden of proof? Sandra, you're on.
Huh?
Preponderance of the evidence.
Best interest of the child.
I thought it was beyond a reasonable time.
Oh my God, guys. You're gonna need to know this for the final. First of all, let's separate out, because my question might be confusing, right? You might say, well, which hearings? Because there's so many in a care and protection case. So let's start with first time the case comes in and there's some kind of temporary hearing. Lester?
Clear and convincing?
No! The first time, I can't, I thought this would be a very quick review, but DCF takes custody of some kids, pulls them from a home, goes to court the next day. All right, I'll make it easy for you.
Is that now 72-hour hearing?
And it goes to court the next day. What kind of a hearing would that be? Pulls the kids.
It's just
That's an emergency hearing.
That's an emergency hearing.
Yeah.
So burden of proof for emergency hearing is what? Really low threshold, remember? Just like getting an injunction.
Immediate danger.
That's part of the legal standard, but not really.
Reasonable belief?
It's a reasonable cause. Reasonable cause. When I first asked the question, I was actually talking about the trial, but no one got that right, so I figured I'd just go back.
And that's the same standard for the 51A report.
Exactly. Exactly. If a
reasonable cause to believe.
Mandated reporter has reasonable cause to believe that a child is suffering from abuse or neglect, that reporter, cop, teacher, etc., should be you know, making a report to DCF. Yeah, it's that same standard, reasonable cause. Emergency hearing, next hearing, which would be a temporary custody hearing, either after the emergency or, if it wasn't an emergency, the first temporary custody hearing. What's the standard of proof for that?
Substantial risk of imminent or serious injury.
Again, that's a legal standard. You want to differentiate, a burden of proof is a burden that the moving party, the petitioner, the complainant has in order to convince the judge, say, that there's substantial injury. All right? So burdens of proof, there aren't that many when you think of burdens of proof. They go way up to beyond a reasonable doubt and way down to reasonable cause.
Isn't this still around the same?
What's that?
Isn't this one, at the level we're at right now, pretty much still the same?
No, reasonable cause is only if the children were taken out on an
Are they
emergency.
clear and convincing?
No. Tim knows. He just doesn't want to say. Preponderance of the evidence, and that's the Robert case that we were saying that Mike Kelly had been the appellate attorney responsible for this standard. Now DCF has had, either has had custody since the emergency, or is, you know, just going in and filing a a care and protection case, and is looking for temporary custody. So it's not the trial, it's not the permanence of the trial, but it should be a little bit higher than reasonable cause, and like an ordinary civil preponderance standard, DCF, the moving party, the petitioner, has to show that returning the children to their parents would result in what you said before, Ash, substantial danger of harm, neglect, or abuse. And then the third hearing is the actual trial, the hearing on the merits, where the standard is. Now we have, and it's the highest you can go for a family case, at least in Massachusetts, in terms of a standard of proof, is what?
Clear and convincing.
Clear and convincing. And that's because the US Supreme Court set that standard in that, remember the Santosky case, Santosky versus Kramer, one of the earlier cases that you had to read. The Supreme Court held that, you know what, this is such an important family right to lose custody of your children permanently, or even to lose parental rights as well. That one happened to have been a termination case. The standard should be higher than just an ordinary civil standard. So no state can go lower than this. So we can never change our statute in Massachusetts to say, you know what, we should make it a little easier for the state. We can't do that. We have to follow the ceiling here, ceiling being the Supreme Court's edict that before parents lose custody permanently, the state has to show by clear and convincing evidence that they're unfit. So these are all civil standards, and that's the reason why I just wanted to segue back a little bit to the care and protection cases, so we can look at the child requiring assistance and get ready for the delinquencies that we'll be doing, that we'll be signing next week. And who's the petitioner in a care and protection case?
Anyone mandated reporter?
Not a mandate, all a reporter does is report.
DCF.
I hear DCF, I'm hearing the state. Anybody else?
Is there a difference between the department and the state? That's what I thought there was.
Well, the department is an agency of the state, yeah. Mm-hmm. Anybody else?
I forget what he said.
What Mike said? Well, Mike was talking about the CRAs.
So say it could flip. I mean, it's possible the parents could turn around and file something before a trial.
If you look at 119.24, it actually talks about, and you're all pretty much right when you say the department, because 99.9% of the time, it's the department. But the statute does say any person. Any person can actually file a care and protection case, and then a person is defined somewhere as over 18. But for the most part, it is the department, and the department, I think I mentioned when Mike was talking the other day, obviously has its own attorneys. So the minute the case comes in, even when it's an emergency and the attorney knows, nothing about the case, the social worker is going to immediately inform him or her, here's my affidavit, filing the petition, blah, blah, blah. The attorney starts the case file, and the attorney is, litigating the case through all of these hearings. And in between the temporary custody and the final hearing, there are status hearings, there might be motion dates, pretrial dates, etc. So you have the attorney handling the case. And the reason why I'm emphasizing that is you're going to see when we get to the CRA cases, you really don't have someone like that that's pushing the case forward, someone like that meaning an attorney. Because in the CRA cases, first of all, before we get to who the parties are and the attorneys, there are four kinds of acts, let's put it that way, that juveniles might do that are not criminal, that have been called status offenses, that have become the subject matter for what used to be Chin's cases and now what are CRA cases. So let's at least just list those out. Somebody give me one.
Running away.
Running away, okay.
Truancy.
Run away. I'm going to put truancy down here. Truancy.
Disobeying the parents or being
Disobeying
Disruptive.
So I call like a stubborn child.
parent.
and acting up in school.
I'm going to use the same word, disobey, Jadita, the school. Disobeying lawful regulations of the school. We'll see some of. Okay, so running away, disobeying a parent, being truant, disobeying regulations, disobeying the school are the four, again, acts that children, now up to 18, do that perhaps will get them into court on a CRA. Just looking back for a moment when I said care and protection of, some children, what gets that case, care and protection case going is an act or an inaction, negligence for example, on the part of parents, right? So now when you're looking at CRA and delinquency cases, you're talking about acts that kids have done. Important distinction. Tim?
Didn't he mention something the other day about prostitution? Is that not one of them?
About what?
At least saying something.
I can't
Child
hear you.
trafficking, prostitution? Is that one of them now?
Yes, you're right. It's part of the new, and I have it, in the memo that I just sent you guys, I just want to make sure that it's not part of, it's actually part of the parent. I'm going to put it up here, so. I'm going to do it like this. So runaway, disobeying parent, sexually exploited child. Those three parents are the petitioners. Just want to make sure I have that last one right, yes. And then if the child is truant or disobeys at school, it's the school that's the petitioner. Okay. Now, some of the cases that you had to read for Tuesday, I'd like to just take a quick look at a few of them, not in a lot of depth, but the first two, Commonwealth v. Brasher and Commonwealth v. Johnson. Notice that the Commonwealth versus Brasher, Commonwealth versus Johnson, and Johnson was a 1941 case, Brasher was a 1971 case. They are actually Chin's type cases. The Chin statute was enacted in like 72 or so. It was after these cases were decided. So before Chin's became law, if a child didn't obey at school, didn't obey at home, you know, again, was truant, ran away, etc., that child was actually prosecuted as a wayward child and sent to those reform schools, etc. But Brasher and Johnson are still good law just for the proposition in them. And if you look at Brasher, Brasher is about actually the stubborn child that doesn't obey a parent. And in that case, the child was living in some kind of home, and so the person in charge acted like, you know, a caretaker, a parent, etc. I guess the child was you know, hanging out at night, making what was then really vulgar expressions, etc. It's really funny. I don't have the quote in front of me. I don't know if any of you looked at the case.
Yeah, I did. It was Fall River, so it was inner city.
Do you have what the child said in front of you, Patricia? I didn't print out the case for class. I just. It's not really important, but it's just it's a funny. What's important about that case in terms of what the petitioner would have to prove? In terms of this, you know, not obeying, you know, lawful and reasonable commands of the parent. So the court said, and this is important, single, infrequent, or isolated refusals to obey commands do not constitute a crime. You know, again, at that time, these acts constituted crimes by which the children were actually prosecuted. Neither do manifestations of stubbornness, which do not amount to refusals to obey commands. The law does not make mere expressions of disagreement or differences of views or opinions between parent and child a crime on the part of the child. But it does not excuse stubborn refusals by children to obey reasonable and lawful commands of their parents. So keep that in mind in terms of when and if these cases go to a fact-finding hearing, that that's what the parent would have to show.
That sounded like a contradiction. So if they continued to be stubborn, then it was something that you would take note of. If it
So
was
again, you know, Mom, I
occasional-
don't, you know, I don't agree with you. I know, you know, you like to go to church every Sunday. I don't believe in God. That could escalate, true, and become what a parent thinks is a stubborn refusal to obey my command. The child could, you know, argue that that's the child's expression, that's the child's opinion. It could even evolve into a First Amendment sort of argument as well. So yeah, it's muddy, it definitely is. And it gets muddier in terms of the petitioner is the parent. Again, when I mentioned the care and protection cases, you have DCF, a lawyer that's, you know, knows the legal standards of proof, knows, you know, legally what he or she has to prove, and, you know, what the next step is procedurally, et cetera. So a parent that's filing an application for what used to be a CHINS, now a CRA, yes, under the new law, and you're gonna see the clerk supposed to help them and offer services, and then there's possibility for informal assistance, et cetera. But in the end, unless there's an issue that DCF could possibly get custody, parents do not have an attorney in these cases. But that's what would have to be proved beyond a reasonable doubt. That you have a kid that's, you know, between, I think it's 7 and 18 or 8 and 18, I forget, it's in the law, that's just stubbornly refusing, you know, over and over again to obey the lawful and reasonable commands of his parents. And the parents say, they're throwing up their hands, right? I just can't do this. I've tried everything I've tried. He stays out till, you know, 2 in the morning. He's only, you know, 12. He's not obeying his school. His room is like a, you know, pigsty, and there's nothing else I can do. And that's their reason for, you know, and again, it used to be called children in need of services. So the deal was, let's prophylactically try and help these kids that are committing these acts now that are not really crimes, but that they could end up engaging in criminal behavior.
Now this one, do you think this would have ended the same way today? Because it doesn't say
No,
exactly what she was saying,
right.
but it doesn't, it seems pretty minor.
Yeah. Did you find, there was
Yeah, I
some
found
funny
it.
quote, in it. Can you read it?
Well, it says, on May 2nd, 1969, the defendant was to see a doctor for complete physical, and she refused to do so. And on that same occasion, she became a little angry, slammed a few doors, and refused to obey the request of the house mother not to slam the doors and not to swear. And then it says there was another time she had several temper outbursts during which she would not respond to the commands of the house parents and used vile and vulgar language of a kind formerly used only by common railers engaged in gutter brawls.
Yes, that's what I was looking for. Say that again. That last part.
Common railers engaged in gutter brawls.
Yeah. And for that
Very
reason,
archaic.
the house mother, you know, brought her to the attention of the authorities and she was prosecuted. Yeah. And that was 1971, not that long ago.
Yeah.
So it was shortly after that that the Chins law was enacted.
I have a question. You said that for parent petitioners, their burden of proof is beyond a reasonable doubt.
All of this, okay.
Oh, all of this.
I'm sorry. So before, when I asked you guys and we summarized what the burden of proof for the care and protection cases were, because they're civil, clear and convincing, the burden of proof for CRA is beyond a reasonable doubt. So this is interesting, isn't it? Because, and it's always been, even when it was Chins. So now you have a case that's still about a kid, and we put the types of acts that the child has done on the board: run away, disobey parent, truant, disobey the lawful regulations of the school. Yet the standard of proof is a criminal standard of proof. Your Honor. And they kept that with the statute change. When the statute changed from Chins to CRA, the drafters did try to make it more civil-like. For example, and Michael mentioned the other day, no shackles anymore. Children that you know, are running away, if they need to be brought into court, they're taken into what's called protective custody rather than, you know, arrested on a warrant. So they did do some things to make CRA more civil, but they still retained the beyond the reasonable doubt standard. And when I asked them the other day, he thinks that it's still possible, it's still an easy standard. According to Mike, I kind of disagree a little bit, but that's okay.
Beyond a reasonable doubt.
Because what he's saying is that it's pretty easy to prove these acts. I'm not sure of some, you know, truancy. Of course, you've got the school official with the, you know, but that again, you know, I've got his, what if I have a sick kid? What if I have a kid that isn't going to school because he's being bullied? You know, there are, you know, it could be questionable.
The runaway, I mean, maybe the kid just decided to hang out with his friend and lost track of time. And the parents, it's he said, she said, I don't know.
Exactly.
When I went to the court, the juvenile court, they did have somebody in handcuffs. Is that because?
It would not have been a CRA kid. It would have been a delinquent or even a youthful offender.
Okay.
Yeah. You didn't notice it, did you hear that case by any chance?
It was a very little thing they were determining in terms of the custody, but I did notice that the guy was.
Our kid was too.
it wasn't to determine his case as much as whether he was going to, something to do with the custody of his kid.
You guys too, Tricia and Joe?
Yeah, ours was a little different. Our guy's lucky, the one we saw in cuffs was lucky to be alive. He's the one that, he took a BB gun or air pellet gun that he stole. He stole the air pellet gun from Walmart that looked like an M4 machine gun. Because he got suspended from school for fighting. Didn't agree that he should have gotten suspended. Goes to Walmart, so he's at home, he steals his mother's car, goes to Walmart, steals an air gun that looks like a machine gun, drives to his school, runs through the hall saying, I'm gonna kill everybody.
You told me about this.
Runs into the cafeteria and says, I'm gonna shoot you all. He gets tackled, the gun gets ripped from his grasp, he escapes, runs back, gets into his car. Meanwhile, cops are calling, they're thinking, another school shooting, Columbine, or Newtown. And he turns into a high-speed chase that lasted, I think they said 20 to 30 minutes with speeds over 100 miles an hour before he finally was trying to get on the highway and was going too fast to negotiate the on-ramp and crashed and totaled his mother's car. So that guy was in cuffs.
Yeah, so this guy, first of all, you could have the school not only suspending him or expelling him or, any kind of disciplinary action within the school. School could also file a CRA, disobeying lawful and reasonable commands of the school. And obviously it gets criminally prosecuted when we start delinquents next week. Either a delinquency complaint could be filed, or the district attorney also has the option of filing what's called a youthful offender indictments for the most
He was
serious
16 at the
crimes.
time, but didn't have a license. I mean, the charges were just.
Yeah, and so he would fall within the youthful offender category. We'll get into more detail with those next week, but 14 to 17, infliction of threat of serious bodily harm, and trial in the juvenile court, but after trial, sentencing hearing in which the juvenile court judge can actually give an adult disposition. So see how it all does interrelate, and who knows, again, that kid is also has serious issues at home. You might have, for example, the CRA law mentions that the probation officer should be filing a 51A in certain instances, once they do the intake and realize that there's, a home situation that might be reasonable cause of abuse or neglect. By the way, Johnson, the older case, 1941, again, still cited for the school offender. For the school offender, you've got to have persistent violation of the lawful regulation of the school, and that's still part of the CRA law. It's still part of the case law as well. A couple of the other cases really go more to what the court can do, and that has been a huge criticism of the Chins cases, and I don't know whether the CRA cases could resolve. And here's the deal, because these cases involve, again, acts that children have done that need to stop, and they brought it to court and supposedly, get services, etc., so that they stop. What if they don't stop? All right, the judges in the Florence case and in the Florence and Vincent, tried to do things like, you know what, I'm giving you a direct order, you better stop or blah, 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 or I'm holding you in contempt. Well, that's beyond the authority of the juvenile court judge. All the judge can do in these cases is order custody. Custody to parent, custody to another person, custody to DCF, and then as a condition of custody, the child gets certain services. And it has frequently been called, the statute without teeth, because other than the child, coming before the court every so often and getting yelled at or whatever, right? There was and probably still is nothing much more that the court can do other than placing the children in DCF custody. That's the worst case. The worst case scenario of a straight CRA, a straight Chins, when I say a straight meaning not like the scenario that Jeremiah just mentioned, is DCF custody. where the worst case scenario of a delinquency case is DYS custody and adult jail if it happens to be a youthful offender case as well. So, you know, what do you do?
I had a question, and I don't know if we're gonna get to it yet. It was on Hillary, and it was a weird statement about the judge cannot find a child making, let's see, it's actually on page 595.
So-
He can't make a decision, a declaration of parental unfitness solely by focusing exclusively on the child. And that seemed like an oxymoron, like,
So
what?
Hillary was the case that set the standard for parents getting counsel in Chin's cases, in CRA cases. Up until, what's the year of Hillary? It's not that long, that old. Anybody have Hillary in front of them?
2008.
2008. So before then, the only attorneys you had in the courtroom when a CRA case got called was counsel for the child. That's it. Even with the school district, it would be somebody from the school. So with the Hillary case, what it stands for is when, if it looks like, and that's kind of hard to determine sometimes, that this child is going to be going to DCF custody, then really you have to stop the case. You have to get a second call and get an attorney in the courthouse to talk with the parent. And of course, as Michael said, the parent could, you know, still waive counsel, but talk with the parent, find out what the parent wants to do, and then from then on, represent the parent. So that's really the important
Okay, so the focus wouldn't be
Hillary.
just on the child, it would be on the parent's interest as well.
Exactly,
Okay.
exactly.
Thank you.
The other thing to remember too is when and remember when with the care and protection cases, we talked about DCF had to make reasonable efforts, and that used to be a federal requirement, but it's now 11929C. It's called the certification that the court makes whenever a child is going to be removed in the home or continues to be away from the home, that the court has to be convinced that before that happens, that DCF has made all reasonable efforts to help this family before removal. Well, that reasonable efforts requirement, you know, it's kind of across the board. It's even in the delinquency cases too. But it's certainly, you know, Mike alluded to it the other day when he said it's similar to a CMP. Again, in the sense that when you get to that point, because when the CRA cases are filed, for the most part, at the time that they're filed, you have kids, you know, living at home, right? And they've been filed either, again, by parent, because they're not obeying, you know, maybe if they run away too, or by school. So the parent is coming to court with the child. And, you know, you're coming and you know, you're hearing from, you know, maybe the school authorities, you know, he's still not going to school, or you're hearing, you know, he's still acting up at home. And that's perhaps when the court is like, okay, what should happen next? You know, he's not progressing at home. Maybe it looks like he needs to be removed from parents' custody. And again, it would be at that point that parents would get counsel as well. And maybe supporting a removal, or maybe not, you know, depending on the circumstances. The other thing is the connection to this, and I please do not profess to be an expert in this, but there's so much overlap with the special education field here. Because if you're representing a kid in a CRA, and that kid is, for whatever reason, not going to school or not obeying, etc., that kid may need, if he or she doesn't have it all well, doesn't have it at the time, an individual IEP, an individual education plan, that you need now as his or her advocate to fight for it, because lots of parents, they don't realize their rights, that they could have been doing this. And up until this point, neither parents nor children, you know, unless they have the financial means, would have hired lawyers to help them out in the process with the school, right?
Yeah, that happened.
Do you have a case like that with Michael?
We had a case like that. One of the kids, he was being charged with tagging different restaurants, graffiti, and
Charged with graffiti in school or?
in school and outside.
Okay.
But what happens is he used to get into a lot of trouble at school, and they didn't want to offer him an IEP. The mom didn't know, so actually that day, Michael told the mom about that. So the next time they go to court, he's going to try to get that done for the child.
And up until maybe a couple of years ago, before the Commonwealth cut down on a lot of costs, the courts would, in addition to appointing a CHINS attorney, a CRA attorney now, would also appoint another attorney called an educational advocate. And those attorneys were, you know, specialized in education law. However,
They don't do
that's,
that anymore?
yeah, and they were called actually GALs, but they were educational GALs. They don't do that anymore, no money.
And no,
so
in the New Bedford Fall River area where there's 2 inner city schools, there's one in the outskirts.
Yeah.
And he's not really busy.
Mhm. Yeah. So now, you know, again, it's more, the responsibility should fall on the child's attorney anyway. So that means that you also have to, your obligation is, right, to adequately represent your client. So now you've got to be schooled on all of that as well, not just the representation in court, you know what I'm saying? Or else you're committing malpractice. Yeah. So let's, we have to read a few cases for today that also segue in a little bit to the delinquency cases that have to do with, you know, student violence in the schools. One was the Nicholas B. case.
It's page 590.
If anybody remembers, what did Nicholas do?
He assaulted another student
Where?
outside of school, a couple of blocks from the school.
Yeah, so he wasn't
Yeah,
on
started.
school.
But it started in,
Started at
like the
school.
argument started in school. They talked about doing it, but he actually did
Right,
it outside of school.
right. And so, what happened?
He was expelled for the rest of the school year. I think.
What did he do? Because notice this is Nicholas B. versus School Committee of Worcester.
He appealed.
He made them-
What?
He was challenging the committee's authority to do that.
What kind of case did he file?
Isn't it constitutional?
Yeah, he filed the civil rights case
Yeah.
against the school. You can't do that to me, right? But
So he was shut down.
he was shut down, Ash. Why?
Tim was gonna tell you.
What's that?
Tim was gonna tell you.
Tim was gonna tell you?
Good one.
But he didn't establish a violation of any state civil rights act.
Why not?
Is it because the students don't have, well, at least in Massachusetts, they don't have the right to go to school.
Yeah, education is constitutional, right?
That's
Yeah.
true, but was that really what
No.
was at stake here?
He was saying that the school didn't have discretion to expel him.
Authority.
Right, authority, sorry, because of this act not happening on school property or during school time. But the court said that the school committee has wide discretion on disciplinary matters when it comes to students and their behavior.
continuation of a confrontation that occurred in school grounds. So
Right.
when does that stop?
I don't think it should, because again, it's, if they didn't have that initial, confrontation in school, more than likely this assault would not have happened. So of course the school should have authority over that.
You're saying like it happened today and then a month from now it starts the fight, right? When did it stop? How is it carried through?
So what are you saying, Tim, if it happened in my?
I think,
Oh,
I'm sorry.
Well, I said Tim, but
go ahead.
Lester wants to cut
I'm
in.
sorry.
No, I mean, I don't know, it's subjective, like a relative cool down period or something, kind of like in a criminal case, I guess. Like, if it's not a continued escalation, then it could be a different thing,
So you're saying a cutoff in terms of time would prevent the school from doing something like this?
Yeah, it's pretty much dropped. It had nothing to do with it, and then another, he just didn't like him, and then something else happened outside of school that really was unrelated to that, besides the fact that they don't like each other. Then I would say that's a separate incident that the school has no business in.
John? I know Lester wanted to say something too.
I have a problem with this case because it seems like the school district is making an end run around the rights of the child. They overreached, in my opinion. Kids get into fights that have nothing to do with school. And I think that they had enough trouble with this child in other school regulation violations that this was just their attempt to get him out of school. And in so doing, violated his rights.
I kind of disagree.
In terms of your answers, to try to think of, every school now has to have their set of rules and regulations. They send home with the students, parents sign off. So the deal is, I'm expelling you, and maybe I'm also going to file a CRA because you've repeatedly disobeyed our lawful and reasonable regulations. So what would the lawful and reasonable regulation be in a case like this?
It's off school property. I don't understand why they had any jurisdiction over it at all. I really don't.
They don't, I don't think the case really argues about, it makes it clear what they're basing it on, but there is this one sentence here that says, Nicholas needed no advisory rule to tell him that his conduct was seriously wrong and contrary to school policy. And based on that there was
Do you think this is a kid they just wanted out of school? For example, the next case that you had to read, the Pierce v. New Bedford case.
Yeah.
Take a look at that case.
I think that's
He has a whole history
Right.
before they decide, the school decides to get him out.
Sometimes I think they might just be scapegoated, like they just really did. Pierce was out of time. If that happened today, nothing would have happened to him. This kid, though, Nicholas, it sounded like for whatever reason somebody just wanted him out, and they had the ability to work the system to make it happen.
Or they're just basically saying this, like their thought the fight really started at school, then they just moved the venue. It's kind of like getting a fight after school and being like, oh, hold up, we're just going to go down the street to the parking lot so we don't get kicked out of school. It's kind of what they're getting at. Really, the fight was there and they just
And
moved
most
it off
schools,
site.
that would have been in the rules, obviously, no
It's like when
fighting,
you're at a
no
school
assaults,
function.
etc. And you could get
school
suspended.
function off site, that's still,
Joe?
I was gonna say, keeping in that, along the same lines, that, a violation, administrative violation of school policy as opposed to a criminal offense. If you look at it as the reverse, if he were to get involved and charged criminally in that case, the school can then still bring an administrative penalty against him for his conduct, even though it was outside of school. So.
Oh, absolutely. So, suppose that, and we don't know much more about the facts of the Nicholas case, but suppose that Nicholas, really, hurt this other kid. Police call, delinquency complaint, is filed. suppose he really hurts him badly, and suppose it's also clear now that it's outside of school, suppose it was at a party that night, okay? The school, I remember we visited at the beginning of the semester, chapter 71, 37H and a half. The school can suspend and ultimately expel for an incident that occurs outside of school if the student's continued presence in the school has a detrimental impact on the rest of the rest of the student body. So whether it's in or out of school, and then there would be other provisions in 37H as well that gives the school the authority to do something like this too.
I was kind of leaning towards that because doesn't the school have a duty to provide a safe environment for its students?
Right.
So now, this incident started in school. His parents can say, how come the school didn't intervene instead of letting it get to this point? So I don't think it's that they just want to, kick him out compared to Pierce, where he has this whole history of, misbehavior. But I think it's sort of they're covering their tracks.
And you just reminded me of the zero tolerance policies that, resulted, way back when after Columbine and so forth. And a good segue into the Milo case, because all the kid did, and he was a young kid in Milo. How old was he? 12. What did he do?
Drew those pictures.
He drew pictures. I like that. This is one of the few opinions where you actually have the graphic on it. The kid with the. So what happened, John?
He drew a picture of
The picture shooting teacher, I think, or just a graphic one. One teacher took it, and then he drew another one after shooting that teacher.
And so what
Went out and
happened?
helped him to the class.
What happened to him?
I was expelled for threatening him.
Was he expelled?
Uh,
Because this is what case is this? Is Commonwealth versus Milo.
oh, right, yeah. So it was,
So see what I mean? When I said before how these cases run into each other, the school.
he's fine, like,
So he gets criminally prosecuted for an incident at school. As well, he may have also been disciplined at school. The school could have also filed a CRA, and again, a criminal prosecution as well. What was his argument?
Freedom of expression.
Yeah.
Yeah.
How old was Milo?
He was 12.
Pretty artistic.
Wasn't a kindergartner recently suspended for a similar act? I forget what school system it was. Or just sent home, but then he was allowed to come back.
This was like last month.
A what?
Yeah, this was like last month or in February.
Yeah.
I don't remember the exacts behind it.
did he
Brought a
just drop
toy
it?
gun. Is that the, brought a toy gun to
Yes.
school?
Yes.
Was he in kindergarten, I
I
believe,
think
right?
so.
Mhm.
Oh no, there was another kid who was eating a Pop-Tart, and this was recently. He bit it, but he into like a shape of a gun, and he was expelled. And he was like in first grade, and they had him on the news. He was like, I just want to finish my breakfast. I was hungry because I didn't get to. They took it away from him. He bit the Pop-Tart like around into the shape of a gun, and he was expelled just for that.
They were overreacting a little
Yeah.
bit for some of this stuff, I think.
This was recently too. I think like February or the end of January.
And again, that's the zero tolerance policies of some of the schools.
Wow.
And the statute gives them that authority.
When you say the statute,
The one that you cited earlier with, I
Oh,
can't-
37.
no, 37H and a half
Yep.
is only about incidents that occur outside of school, that a student can be, ultimately expelled for. 37H still, which is the whole school statute, certainly gives the school the authority do all kinds of discipline for incidents that occur in school, and they're usually spelled out and should be spelled out in the school's handbook. So you have to show that connection, that the child has violated a reasonable, lawful regulation of the school. And usually it's all, no guns, no drugs, things like that, right? And you can be expelled, as well as it could be the basis for the kid being criminally prosecuted as a delinquent child. Lester?
Again, I have a problem with this case.
I know.
There's no gun, there's no drugs, there's no threat.
It was reasonable to fear that juvenile had intention to carry out the threat against his teacher. The SJC said.
Another teacher would have taken the picture, torn it up, and thrown it in the basket.
Right,
And
yeah.
said, let's get on with the lesson.
Exactly.
That's what I did the first time.
The teacher's subjective and, I think, irrational fear. Now, I don't know the child is setting and so forth, but it just seems like this is way overreach, in my opinion.
Yeah.
And went all the way to the SJC on it. So,
I think the teacher too, she kind of provoked him, because after taking the first one away from him, and then she, I was just telling Dutch, I had a student like that. Like, sometimes over the summers, I do VBS in my school, my church, and I had a kid like that, and he would draw pictures of the other kids, like, oh, this is you, and I'm gonna beat you up, and look, but he never did anything. I would just intervene and listen, put him in a corner or whatever.
Right.
But now he's old, he doesn't do these things. So sometimes the kids are just doing it for attention. I don't think it was that serious, like Lester said, to take it. I don't think it was that serious.
In some of these suspensions, I'm not so sure why they don't do all in-house suspensions, because if they're in a room where their classmates aren't, that's going to be a worse punishment than being home.
Yeah.
Plus, it takes the onus away from the parents, or make them do Saturday or something, but an in-house thing where they're still getting their education, but they're confined. And they're not in the milieu of being able to fool around or hang out with other people.
what happens to a kid that's suspended? Or a kid that's
They're
expelled?
home on their own, and unless they petition, they're not even getting the educational services. The parents really have to be savvy enough to make sure that the kids are getting their tutoring or whatever their rights, especially if they have an IEP.
At home on their own,
Yeah.
on the streets.
Which is putting them in a worse situation if they had them in the confines of the school. So they're not doing them in service.
And the
they're-
most amount of juvenile crime actually occurs after school, when
Right.
most kids are home.
Right.
Not in the evenings, not during the day, but just those after-school hours. So the children that don't have, unfortunately don't have anything to do, that we talk about the school to prison pipeline. You get screwed up at school, you're gonna be getting into all kinds of other trouble as a result. And it doesn't necessarily mean that you're such a bad kid either. It's just because circumstances, whether, part of it is your environment, part of it is your personality, and it can become crazy.
Just gonna add, one of the things they do in New Hampshire, I can say is that if they have problems in school, then they're, instead of, if it goes to a level that they're gonna expel them, a lot of times they're trying to put them in the alternative school, like they're trying to do that.
Good, that's good.
They're trying to do that from middle school up, at least in our area, and they have a contract they sign, literally, that says if you violate any of the rules going forward.
And the other schools are willing to accept that?
That's my understanding.
It's in the system. Usually they're in the same system.
Okay,
Yeah.
all right.
I think they have to get in the same type of program, but if they violate that contract,
Okay.
then they're not pretty much not accepted anywhere.
Yeah.
And it's pretty strict. I mean, I've taken a look at a couple, it's pretty strict with what they ask, and they make good community service and all sorts of stuff.
They also have youth court in some of the inner cities, which I think really is a
That's
great program, because they do the same types of things. It's always community service. It's usually sometimes either anger management or behavior mod therapy or whatever it is. So they're doing community service and some type of therapy. Parents have to be there.
Yeah.
And it keeps them out of the problem. Plus it shows them, look, it could get worse. And they found that that's a pretty effective system when they have it in the inner cities.
What's it called?
Youth court?
Youth court.
Youth
yeah,
court. So
yeah.
what they do is they
There's a
actually have
few-
high
There's
school.
some across the country, and there's an annual, like conference, it's usually in Las
Yeah.
Vegas.
Yeah, they have,
Anyway.
it's run by high school kids that act as the lawyers, the judges.
Yeah.
Sometimes they have
That's
volunteers that
great.
will come
It
in and do
really is.
things. And it's, yeah, they have to fundraise for themselves, so that's usually a problem with monies, but, they have, it's a great program.
That's what I was thinking.
Yeah.
That's a fact.
Another thing that's frequently done, not only in the CRAs, but the delinquencies, the, the diversion programs. Let's see what we can do short of actually getting the kid in court, and, going through a fact-finding hearing or a trial. But again, that also depends on families, on schools, on police, on services that are,
School
out
system,
there.
school system protocols, I think, are a big blockade to a lot of doing something
Right.
positive for the kids. If they have it, it's carte blanche, then it's like, look, we're gonna make an example if we don't do that, so we can't. So there's no looking at individualizing a scenario to see what they can do.
And also think about who is the school. Remember the parents' patriarch philosophy. The school is pretty much the parent for the day, taking care of your child.
Babysitting.
What's that?
Babysitting.
Well,
Sometimes.
shouldn't just be a babysitter, but yeah, exactly.
You would hope.
So I want to start delinquency on Tuesday, but I also would like to start with a hypothetical that's really a Chin's case. And I actually printed out for you rather than emailed it to you, but I'll email it as well if you want to take it with you. Early in the semester, I said also that I would skip the segment on gay rights children, so this is a particular child that feels like he's being bullied and ends up acting up at school, and it also could be a crime as well. The school files a CRA. He's filing, so you want to think about if you represented him, what kind of arguments you would make for him. So we'll start with this hypothetical, and then we'll go into all the delinquency, procedures. So if you want to just go through the statute, and I'll point out important sections of the delinquency statute. We'll go over those procedures on Tuesday. So grab one of these on your way out. I'll email it to you too, because I'm going to email it to the night class anyway. But you can bring the hard copy with you to class on Tuesday. Thank you.
Thank you.
Yeah, if you want, you can just move the BlackBerry real